what your take is on it?
Sure. So the indictment is 3 charges, as you've mentioned. It is in Delaware, same jurisdiction where everything, as Tom said, imploded not that long ago. And so, like Tom, I'm expecting to see tax charges either in D.C. or in California. Here's my quick take on this. It is 3 identical charges. They all say exactly the same thing, which is that Hunter Biden is accused of lying on a form when he obtained a single gun. The same gun in each of the 3 counts. It's the same, essentially the exact same charge, which is that he said he wasn't addicted to narcotics when he knew that he was addicted to narcotics. That's the case. It's just charged 3 different ways. I think you're going to see 3 challenges. As Catherine and Tom said, the first challenge is going to be that this was something that now they've charged it as 3 felonies, but a month ago they were willing to actually not charge this at all, to defer it. So the claim is going to be that it's barred by the agreement, the private agreement between the parties. The second argument I think you're going to see is selective prosecution, that this is really just retaliatory action for an agreement that fell apart, and in many ways because the government put in a number of provisions that the court took issue with, and now they're throwing the book at him in a way that's really abusive, that this would not happen to anyone else. And the idea that I think they're going to be helped by the fact that it's 3 charges for the exact same gun, for the exact same conduct. I have never seen that. I mean, it seems really over the top to me to go from a deferred prosecution agreement to we're now going to give repetitive charges on the exact same facts and the exact same gun. And then I think the third thing that you're going to see, which Catherine alluded to, and I'm going to put a slightly different take on it, is that this is not a valid charge by operation of law. The issue that's going before the Supreme Court is the issue of who can be barred from carrying a gun. And Justice Amy Coney Barrett, before she was on the Supreme Court, raised this issue that she thinks that this statute that bars certain people from carrying guns violates the Second Amendment. And the Supreme Court is going to be deciding that issue. That's not what's charged here, though. This is not a crime saying that Hunter Biden did not have the right to own the gun. It was that he lied on a form. And so that's a slightly different charge than was not allowed to possess the gun. This is about lying in connection with a gun. But the reason they think there's still going to be a legal issue is that in order for the lie to be something that can be charged criminally, it has to be material. In other words, it has to matter. Well, if it turns out that the underlying crime of possessing the gun is unconstitutional, which the Supreme Court's going to be deciding, then I think the argument you're going to hear is that whether he lied or didn't lie is irrelevant because he constitutionally could obtain this gun. So that will be the argument. We'll see how that fares in the courts, but it is a real issue. And I think those are 3 things that we're going to see on the part of the defense here, as well as we should certainly expect to see tax charges. But my overall take, in addition to that, is this does not read to me like the government's finest day. I don't think it shows an appropriate use of prosecutorial discretion to go from a deferred prosecution to 3 repetitive felony counts.
Can I go back for a second, Andrew, to the number 2, which is your retaliatory claim? But even before, if it was retaliatory, which, again, it would be the defense making that argument, even before that, is this a case that normally would be brought? Michael Schmidt from the New York Times was talking about how rare this is.
Yeah, that's a great question. And by the way, by my saying it's retaliatory, that's the argument that the defense will make. Right. I mean, the government will respond to that as to why it isn't. But I think you're asking exactly the right question here. I was a prosecutor and in the government for over 20 years. I never saw this charge. I saw lying on forms, but it would be whether you, one of the ways that you could lie is whether you were a convicted felon who's now possessing a gun, and you lie about your being a convicted felon, which is much more serious. When it's not that you want people to lie, and it's not that you want people who are addicted to drugs to have guns, but it is, that is somebody who is, there's a lot of reason to think that they don't even have the mens rea, the intent, which you have to show if they're truly addicted at the time that they are actually purchasing the gun. And so that is just not commonly charged. I think it was, it may have been the former U.S. Attorney Lamb who said, and I agree, that when you see this charge, which is very rare, it's usually in an addition when somebody's being charged with other things. And that's not what's happening here. And so it is an extremely rare crime, in my experience, to see. And of course, I was in New York and in D.C., where basically there were a lot of other and bigger crimes. It may be that in smaller jurisdictions this is more common, but I do think that you're going to be hearing a lot about that from the defense, because it's hard to see that they won't make that argument. There's no real downside to them to bring that argument about selective prosecution and retaliation in this case.
Let me bring in NBC's